Welcome to The Explainer. Today, we're breaking down a really important topic, advance directives. These are basically legal tools that make sure your healthcare wishes are followed, even if you can't speak for yourself. So let's just dive right in with a big question. Imagine something happens, an accident, a sudden illness, and you can't communicate. Who makes the big decisions about your medical care? It's a tough thing to think about, for sure. But without a plan, things can get really confusing and stressful for the people you love, right at the worst possible moment. So here's our game plan for this explainer. We're going to cover what happens if you couldn't speak, how these directives actually give you a voice, what your rights are, what doctors and hospitals have to do, and then how you can actually plan for your own care. Right. So that whole scenario is exactly why this kind of planning is so crucial. And look, this isn't about being morbid or planning for the worst case scenario. It's really about making sure you get the care you want and providing total clarity for everyone when it matters most. So what's the solution here? Well, it's a really powerful set of legal tools called advance directives. Basically, these are documents that let you spell out your preferences for medical treatment ahead of time, so your voice is always heard. Okay, let's get into the official definition. See, an advance directive is a written instruction that's recognized by state law. That's the key part. It's not just a casual chat with your family. It's a formal, legal document that only kicks in when you're incapacitated and can't speak for yourself. To make this real, let's look at 4 common types you'll see in Texas. You've got the directive to physicians, which most people know as a living will. Then there's a medical power of attorney, where you pick a person to make decisions for you. There's also a declaration for mental health treatment, for psychiatric care. And then there's a really specific one, the out-of-hospital DNR. This one tells first responders, like paramedics, not to perform resuscitation. Now, for this form to be valid, you have to use the official Texas one, get it signed by your doctor, and then you have a choice. Either 2 witnesses have to sign it, or you can get it notarized. Once that's all done, you got to keep the original somewhere super obvious, like on the fridge, so EMS can find it in a heartbeat. And it's really important to get this. Having a say in your care isn't just a nice idea. It's your right. Federal law actually protects your ability to make these decisions, no matter where you are in the healthcare system. So the crucial point here is that these are legally guaranteed rights. You have the right to get information about this stuff, the right to actually create a directive, and, this is a big one, the right not to be treated differently whether you have one or not. And if you ever feel like those rights are being ignored, you can file a complaint with the state. But this isn't a one-way street. The law also puts very clear responsibilities on your healthcare providers. We're talking hospitals, nursing homes, home health agencies, you name it. They have a duty to help you exercise your rights. So when should you expect to get this info? Well, it actually depends on where you're getting care. A hospital will give it to you when you're admitted, but a home health agency, they have to give it to you before they even start your care. It's all designed to make sure you're informed at these really critical moments. Think of this as the provider's checklist. They have to give you written information, they have to ask if you have a directive and put it in your chart, and they have to make sure their own staff and even the community are educated about all of this. It's a whole process designed to protect your choices. And this is absolutely fundamental. Your access to care can never, ever depend on whether or not you filled out one of these forms. It is always your choice, and you can't be pushed around or treated differently either way, period. Okay, so how do you actually put this all into practice? Let's talk about the concrete steps you can take to start planning your care. So understanding the main documents is key. A directive to physicians or living will is about what treatments you do or don't want in a very specific terminal situation. A medical power of attorney is about who is the person you trust to make these calls for you. They can work together, and they can also work alongside those super specific forms like the out-of-hospital DNR we talked about. But honestly, beyond just signing forms, the most important part of this whole thing is the conversation. And the healthcare world has really recognized this. It's not just some casual chat anymore. It's a formal medical service. And this number right here is the official billing code for advanced care planning. What that means for you is that you can actually schedule a dedicated appointment with your doctor just to talk about your values, your goals, and what you want for your care. They can help you get it all documented. It makes the whole process official. And that really brings us back to the entire point of all this. This quote from the federal regulations just says it all perfectly. The whole system is designed to do one thing: enhance your control over your medical treatment, even when you can't speak for yourself. So we'll end with this. You absolutely have a voice in your healthcare. The forms are the tools, sure, but the real power, it comes from having the conversation with your family, with the person you choose to speak for you, and with your doctor. That's what gives your voice its real meaning. Have you had that conversation?